Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer. I want to share with you a recent case from the Northern District of Illinois, and it involves Bank of America. And I want you to understand and appreciate the ridiculous arguments that these companies make when you sue them under the Fair Credit Reporting Act. So some of the case decisions we go through are really, really long. This one's not long, so we'll go through this pretty quickly. So pretty simple. Bank of America is sued saying they violate the Fair Credit Reporting Act. And so that's section 1681 S2B. That's where we dispute to the credit bureaus. They go to the furnisher, Bank of America. Bank of America does a lousy investigation and the information is kept. Then we sue under 1681 S2B. And then 1681 N and O, that's when it's a negligent violation or a willful violation of the law. And the basic gist is the plaintiffs say, you're claiming we owe you money when we do not owe you money. And so you failed to reasonably investigate, you gave false information, and you were negligent or willful. And Bank of America moves to dismiss the complaint. Judge tells us right up front, I deny the motion. So basically what happened is plaintiff had a condo with two mortgages. The first mortgage, I think that was Wells Fargo, they foreclosed on it. And at least as this case is describing it, under Illinois law, once that happens, it's like you're done. There is no deficiency, okay? And so it says here in this highlight paragraph, nothing in the final judgment foreclosure reserved Bank of America's right to pursue a claim for money damages, yet they sought collection of over $9,000. And that's related to a second mortgage. And they reported that disputed debt to Equifax, TransUnion, and Experian. And so Bank of America says, well, look, you do owe the money. And the judge says, yeah, the plaintiff's claims would go nowhere if the debt's valid. In other words, if you really do owe $9,000, then it's entirely appropriate to report that you owe $9,000. And then the court goes through this Illinois law. And here's Bank of America. Plain language of this section does not allow for the interpretation that Bank of America has. Expressly states vesting of title by deed shall be an entire bar of all claims of the parties to the foreclosure. And so now look, every state's different. Don't interpret this to mean in your state that this is what the law is. It just, you have to know after a foreclosure, is that the end of the story, or can they come after you for more money? And Bank of America says, well, our case is different. And the judge says, no, it's not. And then Bank of America says, well, let's back up. Foreclosure of a mortgage does not affect the mortgagee's rights, if any, to obtain a personal judgment. And that's what the court says. This is so common with these big companies, with big law firms that defend them. To the contrary, Bank of America's argument borders on deceptive advocacy, as it selectively omits the beginning of the cited provision. So I want you to think about this. Huge bank, I'm sure they have a huge law firm defending them, and they quote this law to the judge, but they leave out the first part that says, except as expressly prohibited by this article. And then the judge says, because 15-1511 articulates just such an express prohibition, defendant's omission of that phrase is not well taken. This is the judge saying, look, you guys tried to be sneaky. You tried to lie to me. You tried to deceive me. I don't appreciate that, and I caught you on it. And what this normally will mean is that judge is going to be watching those lawyers in Bank of America. Nothing they say will have credibility. It's always going to be like, well, let's see, I wonder, did they leave something out? Are they being deceptive? That's the price you pay when you do this type of nonsense. We see this all the time with the big companies. They just seem to have no conscience. You know, they'll say anything, as ridiculous as it might be. So then the remaining grounds are kind of meaningless. They say, first, plaintiff failed to plead adequately, in other words, to put in the complaint, that the reporting was inaccurate and did not comply with industry standards. The judge is like, wait a minute, let me make sure I understand it. They said, the plaintiff says, I owe you nothing. You say they owe you money. That's inaccurate, okay? But a report stating plaintiffs owed money when in fact they owed none is certainly inaccurate. And then this deal about industry standards, that would be things like Metro 2. And we had a video on that with the CDIA in their Metro 2 manual. It's just their industry standards. It can be helpful, but that's not the law. It says even assuming compliance with industry standards is relevant, that's not an issue to be resolved at this stage. And the Bank of America, they always say this. All these companies do. No matter, like you could lose your mortgage, be homeless. You could lose your top secret security clearance. You could lose your job. All this stuff, and they go, well, plaintiff has no damages. I don't see how anybody could possibly be bothered by any of this. That's what these lawyers in these tall towers say, and they act like they can say this to a jury. It's one thing to be the hero behind the keyboard, right? And they're typing up, nobody could possibly be hurt. It's a little different when they're standing, looking a jury in the eye saying, oh yeah, we put this false credit reporting and it did this and that, and you haven't been hurt at all. That's when they kind of lose their nerve a little bit, or where you see these big verdicts because they do have the nerve to say this stupid stuff, and a jury's like, what's wrong with these people? Okay, so let's go back. It says this argument too is premature at this stage. And then they're fussing Bank of America is because the plaintiffs want an order that says they do not owe this debt, and Bank of America is to leave them alone. It says they've articulated an actionable dispute over whether they owe any debt to Bank of America, and if plaintiffs can establish they do not, they may be entitled to a declaration to that effect. And if dunning letters, just collection letters, they claim to have received suggest that a non-existent debt is owed, they may be entitled to an order telling Bank of America, stop sending those letters. Okay, so that's the whole case. Again, I just want you to see as an illustration what these companies will argue. That, they'll leave out the critical part of a statute and argue with a straight face to a judge, at least from behind a keyboard, that, oh, we're totally entitled to win this case. The judge is like, no, you're deceiving me. Okay, so just understand that's what you're dealing with. Now, we can get mad about it, or we can say, this is just who they are. They're just dishonest companies. These companies that will violate the Fair Credit Reporting Act, violate this law, that law, and then refuse to admit it when they get caught, refuse to apologize. Why would we be surprised when they continue their deception, both with the consumer and even with the court? So, hope you found this interesting, and I'll talk to you tomorrow. Bye-bye.